that the judicial power and the presidential elections that Michael and Paul and others on the right wing especially are concerned about. Agenda item 4 is talking about re-engineering the Electoral-College to harmonize more with common law, because in the name of God, our electoral polling process is seriously messed up in the way that we are deciding on who will be in control of the nuclear trigger of the most powerful military on the planet. I do not have a whole lot of confidence in either Donald Trump or Joseph Biden being in control of that kind of power. And the point here is we need better process for how the Electoral-College that's specified in the U.S. Constitution for electing a president, that concept of an Electoral-College, it's based upon our common law jurisdiction qualified electors. And see, registered voters are different than qualified electors. Registered voters are basically 14th Amendment slaves. They're legal fictions like what Lewis talks about, and you can take control of it and still exercise the vote there if you've got some type of legal insulation to make it clear in the records of the appropriate county court recorder or whatever that it's not really the flesh and blood person that's exercising that 14th Amendment slavery privilege. It's the legal fiction corporation that is exercising the vote there. So I haven't voted in the last election, but maybe Lewis or some of the others are. But the larger issue is that our current election process is seriously messed up. Okay, and the manner in which I'm focusing here in this Agenda Item 4 presentation is that the individual precincts where the voting is to be counted, they have authority to take back control. If we got the there in Arizona, in the case that Michael and Paul are entangled in, and I've advocated this in our recent right-wing conferences on Monday evening, and Michael's focusing at the Senate, and Paul was kind of joining with him, I do believe. Please correct me a bit later here if I'm wrong on that, fellas. But a lot of focus is looking to the higher nanny state authority to come down with a stick and whack on those county commissioners that are so corruptedly manipulating the vote count. I do believe that is true from the evidence available thus far. I may be wrong. But that's not how common law and organic constitutional law provides the remedy. The remedy is not top-down authoritarian from the Arizona State Senate in that case. The remedy under constitutional organic common law is to organize in the precincts and go marching into those county commissioners' offices and tell them, look, you need to either correct the records here or else turn the paperwork over to us, which we are the precincts. That's where constitutional vote counting is supposed to be taking place anyway. And either we will decide or you start implementing new policies or else we're going to remove you from office with whatever force is necessary. We've got the right to do that because that's the common law jurisdiction and right of the precincts, the 100 courts. They can go anywhere they want and do anything they want if they are justified under due process of law. That's the way it is. Sorry, it was written in stone back in 1789 in the Constitution, and when the Bill of Rights was adopted and the 6th and 7th Amendment were specified, we got the horsepower, we got the moral high ground, we got the legal high ground, and we can do this if we just get the people to follow the plan. It's not a secret plan like that goofy thing QAnon is doing. Trust the plan. I'm sorry, that's goofy. Our plan is open and on the table for everybody to see here, and it's seriously empowering. So, anyway, that's kind of what I wanted to focus on in Agenda Item 4. I think that judicial power from the precincts, and the precincts are constitutionally to be the source of the vote counting. And yes, thank you for bringing that up, Lewis. The quotes from Oregon statutes about Court of Justice. There's other specifications, quotations from Oregon case law and things that say that every precinct in Oregon, at least in the earlier days, had the power to have its own court of justice, and I haven't found anything that says that's been taken away. And so the quote that Lewis is highlighting here is excellent. It's worthy of reading. See, this is a common law jurisdiction court. It's a court of justice, and this is the same type of courts that are referred to in the Sixth Amendment as the trial of all crimes shall be in the state and district within which the crime shall have been committed. That word district, there's lots of case law that says that word district, that's municipal gobbledygook. It really means, in common law jurisdiction terms, it really means precinct. Okay, we got the case law to prove that. And so these precinct-level courts of justice, they have the power. This is Oregon statutes, ORS 1.010 and 1.020. Every court of justice has power to enforce order in the proceedings before it, or before a person or body empowered to conduct a judicial investigation under its authority. This is what I'm advocating to Michael and Paul, that they move forward in the Arizona case or other cases by claiming to be authorized by this court right here, the Supreme Court of Law of the USA, to conduct a judicial investigation. I claim that this court has that authority, and we have the authority to deputize Michael or Paul or anybody in Arizona to conduct a judicial investigation as articulated under the general common law principles applicable in every state in the union, but articulated specifically in this Oregon statute that authorizes people, individuals, to conduct judicial investigations under our authority. We can go to the mattress on that one. And subsection 5 on this, continuing on, every court of justice has power to control, in the furtherance of justice, it's got to be in the furtherance of justice, to control the conduct of its ministerial officers and of all other persons in any manner connecting with a judicial proceeding before it, in every matter appertaining thereto. Okay? Every matter appertaining thereto. Any person connected, all other persons connected with any judicial proceeding before it. This is the importance earlier of our 6 cases before us so far. When we see, the power doesn't come from our Supreme Court of Law. It comes from the person bringing the complaint before the Court of Justice, the Court of Law. The person making the complaint is the one that invokes the jurisdiction. He's the battery that generates the spark, that lights the flame, that makes the justice move forward. So, I kind of got a head steam going there too. I should probably throttle back and ask if anybody has any constructive criticism, first of all, to share with me, and thereafter any comments or questions. Any constructive criticism from anybody there?
Yeah, take a deep breath and relax.
I'm kind of angry at these jackbooted Nazis. Thank you, Matt.